Hi, I'm Wayne Harper of Harper IP Law, and today I'd like to share with you 5 questions you need to ask when you are thinking about getting a patent. Almost everyone comes up with a creative idea now and then and thinks to themselves, I should get a patent on that. Most people never take it further than that, but some people do decide to pursue a patent. But getting a patent is serious business. Many people try and fail to obtain a patent, and perhaps more obtain patents that aren't worth the paper they're printed on. There are 5 questions that every inventor should ask themselves before they begin to pursue a patent on their invention. Question number 1. Has someone else already thought of your invention? No matter how creative your idea is, unfortunately, there's a good chance that someone else has already thought of the same thing. They may not be selling the invention, they may never have even built it, but they might have filed a patent application that describes your invention. So you should do at least a brief search yourself to see if someone else has already tried to patent your invention, or if they are already selling it. So do a search for your idea on Google and Bing at a minimum. Then search for your idea on Google's patent search query. If you see your invention turn up exactly as you thought of it, then you need to walk away from it, or to change it in some meaningful way. If you want a more thorough search, you can have a professional search done for you by a patent search firm. Question number 2. How big of a market will there be for your invention? No matter how creative your idea is, and how unique it is, if no one wants to buy it, well, there's no sense in trying to patent it. You may not be a marketing expert, but you still may be able to guess what the potential market is for a product. For example, an inexpensive product for hair care might find a large market, but an expensive tool that might only be used by a few thousand highly specialized mechanics obviously has a small potential market. Question number 3. Can your invention be profitably manufactured and sold? Even if you can sell tens of thousands of units of an invention, if by the time the product is manufactured and sold, you can only realize a profit of $1 or $2 on a single unit, it might not be worth pursuing a patent for the invention, or possibly even trying to manufacture and sell it at all. Not only are patents expensive, but having many inventions properly engineered and setting up a manufacturing process can be time-consuming and expensive as well. Finding and targeting a market for your invention is also time-consuming and expensive. By the time you get done, you might make some amount of money, but find yourself working for less than minimum wage. Question number 4. Are you prepared to spend the time and money it will take to get a patent? Patents can be expensive. If you use a patent attorney or a patent agent, you'll pay thousands of dollars to have the patent drafted. You can go to a low-cost provider, but it will still cost you several $1,000s, and you may get a low-quality patent that's worth considerably less than what a well-drafted patent would be worth. Many inventors draft patents themselves, and some of them are very high quality. But if you've never written a patent before, you will have to invest a great deal of time studying well-written patents and thinking about your invention. But if you have more time than money, it is an option. Question number 5. Are you prepared to assume the risk you will not get a patent? There are very few inventions that are so unique that it is virtually guaranteed that a patent can be obtained on that invention. Even if you do have a well-drafted patent on a unique invention, it can be hard to predict what an examiner is likely to do. The quality of patent examination at the USPTO is very spotty, and oftentimes examiners make rejections that are simply wrong. Sometimes it's due to inexperience. Sometimes examiners whose first language was not English will interpret patents to mean things they simply don't say. And sometimes the examiner simply doesn't understand the invention as it's described in your patent. Statistically speaking, the allowance rate for patents varies over time between 60% and 80%, roughly averaging about a 65% allowance rate. Thus, anywhere from 20% to 40% of patents filed with the USPTO are never issued. And the allowance rate for some technologies is actually much lower. If you're going to pursue a patent, just remember you have no guarantees. Please feel free to call us at 813-892-7839 if you have any questions. Thank you.